Since last year, Opposing Views watched closely the arguments surrounding the Cybercrime Prevention Act of 2012.
The internet is not there to be controlled. The internet provides opportunities for people to express themselves, to do business, for the public to communicate with their government.
Let's focus first on your premise. Now, but once 33 million Filipinos have access to the internet, then you must protect 1/3 of our people who have access to the internet.
The Cybercrime Law, or Republic Act No. 10175, was approved in 2012. But the Supreme Court issued a temporary restraining order indefinitely after several petitions were submitted against it. The said act was created to address legal issues. These offenses include cyber squatting, cyber sex, child pornography, identity theft, illegal access and hacking, computer fraud, device misuse, and libel. Just last Wednesday, the Supreme Court has approved most parts of the cybercrime law, except for the following: unsolicited commercial communications as a cybercrime, real-time collection of traffic data, restricting or blocking access to computer data, and online libel to those who simply receive the post or react to libelous materials. But the highest court of the land declared online libel constitutional for the original author of the said material.
The court also ruled on the constitutionality of online libel.
Stop cyber martial law now!
The controversial declaration of the Supreme Court has divided the nation, online and otherwise.
Because libel is libel. Even with or without the cybercrime law, libel is libel.
I just think it was a bad idea for the Supreme Court to look on internet as another form of publication. It's not another form. It's not like radio, TV, or print.
Senator T.G. Gingona filed a bill yesterday seeking to decriminalize libel, but the other side believes that there is a need to police the very fluid medium of cyberspace. Their statement is well exemplified by President Aquino's defense favoring online libel.
Welcome to Opposing Views, a hard, straightforward discussion of today's most pressing issues. We used to know cyberspace as the venue for free exchange of ideas, opinion, and a venue to critique the government. And we have yet to determine whether the online libel clause as part of the cybercrime law will change that landscape. So we ask tonight, is the online libel clause of the Cybercrime Prevention Act of 2012 be beneficial to the country? Good evening, I'm Rod Nepomuceno, and this is Opposing Views. All right, joining us tonight in our discussion is Attorney Chris Lau. He supports online libel. He's also an anti-cyberbullying advocate. Attorney Chris, good evening.
Good evening.
Yeah, can you give us your 2 cents worth regarding this issue, this very thorny issue?
Yes. I'm not surprised with the decision at all. After all, the Supreme Court decides in accordance with law, and that means in accordance with the Constitution, to which every other law must conform. So, for me, the Constitution is just an outline of rights and duties, and these duties flow from this general principle of duties that everybody has. We all have rights, but so do other people. So when these overlap, we see chaos. So we have to prevent the overlapping.
All right. Now, on the opposing side is Attorney J.J. Dicini, professor at the University of the Philippines College of Law. He is against online libel. Attorney J.J., good evening.
Good evening.
All right, a summary of your position on this,
So
JJ.
my position is that I think online libel should be decriminalized. And for that matter, I think libel itself should be decriminalized. I think that, although protections are in place in jurisprudence that allows people to, say, freely criticize the government, unfortunately, those protections are not evenly implemented. And as a result, there is a chilling effect that libel has with respect to the ability of people to criticize government and to comment on matters of public interest. And I think that is harmful for a well-functioning democracy. All
right, so let's start our discussion, and we'll take off from that, JJ. you feel that it will definitely curtail freedom of expression and the press, and you feel that this makes it unconstitutional, right?
Yes, so I think that so the issue about freedom of expression and freedom of the press, the purposes for these freedoms is that individuals should be free to or not be restrained from criticizing government, criticizing matters or making comments on matters of public interest. And libel law, or the threat of a libel suit, or the threat of imprisonment because of libel, restricts people, makes them pause and say, should I post this? Should I make that comment? You say, oh, well, maybe I won't. Even though that kind of speech, which we call political speech, is very beneficial to a well-functioning democracy.
And protected, should be protected.
And should be protected, yes.
Right. Okay, now, Chris, your thoughts on that? Do you think that if we continue this, criminalizing online libel, do you think that it will curtail the freedom of expression and the freedom of the press?
Absolutely not. I think by arguing that way, we're going back to the takedown clause. And the reason why the Supreme Court, although we don't have a copy of the decision, we can only surmise, but I believe this is the basis of the decision. The reason why one is struck down as illegal and the other was upheld is precisely because one abridges freedom of expression because it's a form of censorship, that you are not allowed to speak your mind because regardless of the content, before it is even adjudicated to be protected or unprotected, you are not to say anything, and because we can invade that, as opposed to online libel, which is not censorship. You're allowed to say whatever it is you want. Yeah, you can express yourself, but if the content is determined to be unprotected speech, you are held accountable.
All right. Now, let me continue on with this discussion. I guess I'll make reference to a statement made by the president himself regarding this decision. He defends the online libel clause, and his argument, of course, is that kung wala kang kasalanan, wala kang kailangang katakutan. So, do you believe in that statement?
Yes.
Do you subscribe to that?
People say that there's a chilling effect. But the best argument that they can put forth is that it has a chilling effect because people are unsure whether or not, people are scared to express themselves because they don't know if the expression is protected or not. So the last time I checked, ignorance is not an excuse to remove protection altogether. And the last time I checked, everybody has a duty to inform himself. So if you're informed, you know that there's nothing to fear and that you're only guided by the question. In saying these things, or in expressing myself, is my goal to destroy somebody's dignity, honor?
So if the answer to that question is yes, then it should not be protected.
Yes, then that's unprotected speech.
Okay, JJ, your thoughts on that? We need some kind of protection from I guess, libelous statements, both you and I and the government.
Right. So I think where the president is coming from is he's saying that, at least my understanding is that there are people who feel that if the law is not so clear, so he's saying if you have nothing to hide, and if you know that you're doing something wrong, then you have nothing to fear from the law. And I think the problem with libel law is it is almost inherently, or in many instances, it's difficult to know whether something you say is libelous or not. So it's a question of, there's a question of
subjectivity, I guess.
There's an area of subjectivity. And therefore, in areas where there is some doubt, especially when there's a threat of going to jail, then the tendency of an individual is not to express himself. So in that sense, he's engaging in self-censorship. Now, when you increase the penalties, engage in, as we are doing now for online libel. What we're doing now is we're even creating even more disincentives against people expressing themselves. And I think that's harmful in a well-functioning democracy. Because what we want is a marketplace of ideas, so to speak. We want to hear from many voices on many issues because it's beneficial for decision makers. They need more information in order to make correct decisions.
How do you limit that freedom, though? And I'm just taking off from what Attorney Chris said. There has to be some kind of parameter and limitation when it comes to the freedom of, just like any other freedom.
That's right. That's right.
Your freedom ends where my freedom begins, right?
That's right. Well, okay.
right.
That's right.
I have freedom. I'm just playing devil's advocate here. My freedom ends. I mean, for example, it's my freedom also not to be hit or criticized and thrown libelous statements, diba? So where does I guess the question is, how do you draw the line, so to speak?
Right. So
when it comes to online.
That's right. So there's constitutional law cases on this matter where if the subject matter or the object of the speech is directed at a public figure or a government official, for example, then it is a speech that's protected with a higher degree. In other words, the complainant must prove that the person who committed libel had actual malice. Whereas in other forms of libel, if it's a libel between two private individuals, then the malice is presumed in the statement. So you can see then that the court, through these decisions, are trying to put roadblocks in order to ensure that criticism on public issues and comment on public issues can push through. But what I've seen in practice, what I've seen is that this particular policy is not properly implemented. And what happens, we've seen this even during the phase of the TRO by the Supreme Court, where an individual, in this case Cyberperling, in the province, she blogged about the public functions, exercise of public functions of a mayor. And as a result, she was charged with libel. And in fact, the case went all the way to court, and now it's pending in court. So this is a situation where the case will eventually be dismissed by the RTC. Because the New York Times versus Sullivan protections will come into play, but that will be 2 or 3 years after, and at that point,
in the meantime, she's going through this.
She's spending money. She's and then future expressions will now be curtailed. She will think, now if I say something against mayor, I'm going to get.
That's where that goes. Now, I know, Chris, you have something to say, but we need to take a short break. So in the meanwhile, join the discussions online. Like us on Facebook at facebook.com/SolarOpposingViews. Follow us also on Twitter at opposing_views. Use the hashtag #OVOnlineLibel. Stay tuned. You're watching Opposing Views. All right, welcome back. You're still watching Opposing Views. We have with us Attorney Chris Lau and Attorney JJ Dicini. Our debate question tonight is the online libel clause of the Cybercrime Prevention Act of 2012 beneficial to the country. Now, before we took a break, Attorney Chris, Attorney JJ was making a point that there was a blogger who wrote some scathing remarks about his or her mayor, and that mayor went after her. And then, so now, obviously this case is going to go on for several years. And now, obviously, her freedom to express herself is unduly curtailed. I'm sure she'll think twice now. So what are your thoughts on that?
Well, I think it barely scratches the surface because you're arguing on the level of implementation as opposed to on the level of the law, the merits of the law. So these two things are worlds apart. They're different. Implementation is not the same as the merits of the law. So if we argue on the level of implementation, why don't we just scrap all penal laws? Because after all, they're all subject to abuse. So yeah, every now and then somebody will file a frivolous case against you. But when that happens, because there are not cases out there. I mean, society is not complete without them. But as much as possible, we'd like to reduce their existence because that's our concept of a well-ordered society. But in the event that a frivolous case is filed against you, do you scream system failure? I don't think so. You go through the process, and you go through the process. It's a hassle. I tell you, it's a hassle. But hassle is not a very good argument to remove protection altogether. And when you are subjected to this frivolous suit, it doesn't mean that you're guilty. Again, we have protections, right? The Constitution presumes that you're innocent until the contrary is proved, so on and so forth. No one can be held. No one can be detained solely on the basis of one's belief, aspirations, and then that's assuming, of course, that what do you call this? There are safety nets. So that's what I'm saying.
There are safeguards already.
There are safeguards. Libel is very difficult to. It's very difficult to sustain a conviction under libel because. You have to
many elements you have to prove.
You have to prove a concurrence. You have to prove a concurrence of a host of elements, like what you said imputes the commission of a crime, that it tends to cause dishonor, and most striking of these is the element of malice.
Yes. Precisely my point. I mean,
which is difficult to prove.
If it's difficult to prove, and we don't know whether something is libelous or not, and if the protections are not evenly in place or implemented, then the harm that libel, of these frivolous suits actually multiplies. And what I'm saying is that let's just decriminalize it. And let's just, if people are truly harmed, they can sue for damages. I'm not saying there should be no remedies. I'm saying why does somebody have to go to jail when we can have a regime that you don't have to go to jail, but we will have more expression.
No, in this case, like close to 8 years, right? Close to 8 years.
Right. Yeah. So especially now where we've increased it further from 4 years to 8 years.
Let's go to that. Let's discuss that. I think under the new law, or under this law, not that new, because the Supreme Court actually, this is 2012, no?
That's right.
So the Supreme Court just basically declared portions of it, or a big chunk of it, as constitutional. So, but they didn't question the penalties. And we were discussing this earlier, that the penalties are raised one level higher than compared to the traditional libel.
That's right.
And this could amount to around 8 years. Do you think this is fair? I mean, 8 years.
I'm afraid that online libel, if it's punishable at 8 years, I mean, this might be somebody who is in his home clothing. He's in his pajamas at midnight. He gets pissed off at something that he read.
He has too much coffee. Too much
coffee, or maybe he's too tired. He's too frazzled, and he fires off this comment on some board, and then he finds himself facing 8 years in jail. So I think that's a bit too harsh. I don't mind if somebody sues him for damages and proves the amount of damage that was suffered by that individual.
Right.
But I think 8 years is a bit too much for
Chris,
expressing himself.
Your 2 cents worth on that. Do you think that that kind of punishment is too much for something that you might have said maybe carelessly?
As I said yesterday, this is delegated to the wisdom of Congress. If Congress thinks that this is,
but do you think it's
this
fair,
what makes it effective? This is what makes it an effective deterrent. Then that's beyond the review of the courts. But as people, if we disagree with it, like I can understand you. Maybe it may be too much. So the remedy there is to ask for an amendment. After all, we are
now, Senator Angara, when he guested here, and we were tackling a similar topic, actually the cybercrime law as well, but not specifically in libel. He said in his during his guesting that libel in tri-media is the same when committed in the new media. So there's no difference. Of course, I think we saw in the video, Senator Santiago doesn't think so. But do you think it's the same? Do you think?
Well, it's a different medium.
It's a different
so the fact that it's a different medium, it may have different characteristics which would justify the different treatment afforded by law.
Right.
But for me, it's just a different medium. But it's treated differently because of it's more effective to libel somebody when it's done online.
Yeah.
It's cheaper. And then it has presence. A newspaper may be in circulation today, but not be tomorrow, so on and so forth.
Whereas before, if you wanted to say something libelous in the newspaper, you have to go to the editor and the author. And then if you wanted to go to TV, for example, and say something libelous, you have to be a guest of that show. So, so it's a little bit more difficult.
Yeah. So in the hierarchy of things, the lowest would be oral defamation because it dissolves, it evaporates.
It evaporates in the air. Yeah.
Just like that, and then. Next to that would be newspaper publications, because they
Attorney JJ, your thoughts on Senator Angara's comments?
Actually, I think so. If his position is that it's the same, then he should be punished in the same way. I think he's contradicting himself when he says that, because in the law that he authored, he imposed a higher penalty for online libel. Now, if he's saying it's the same, then the penalty should be the same. And I think that there are certain presumptions that are wrong when one says that just because you use ICT for libel, that the harm is greater and therefore you should be punished with a higher penalty. The assumption is that the more people can read it. That's not true. I mean, I once handled a case where it was an email sent to 3 people, and because it was more than under libel law, if you send it to more than one person, it's publication. And I'm saying, why should an email sent to 3 people why should I go to jail for 8 years? Where if I publish the same thing in the Philippine Daily Inquirer, then I only go to jail for like 4 to 6 years. It doesn't make any sense. There's this presumption that just because you use ICT, the harm is greater. What I would rather see is a law that says that when it's a demonstrated increased harm, then the penalty should be increased, not simply because ICT is involved.
There's also an argument, I think you brought this up earlier, that since this is a special law, therefore malice is not really required, right? It's a mala prohibitum.
Right.
So can you expound on this further, and then I'll ask your thoughts.
It's a peculiarly lawyerly discussion, but so there are two kinds of crimes. One is mala in se, and that's the standard crime where you need to have criminal intent. If you don't have criminal intent, then you don't go to jail.
Yeah.
And then there's mala prohibita, where even if you didn't intend to violate, then you can still go to jail. Now, there's an argument here that the Cybercrime Prevention Act is a mala prohibita law, and therefore, if you unintentionally engage in cyber squatting, and you did not intend to engage in cyber squatting, but you unintentionally commit cyber squatting, you can go to jail for cyber squatting. So I'm not sure whether or not the court will rule in that way, but there is a lot of case law that supports that view, that because this is a special law, it's a mala.
So in effect, if you didn't mean any harm, or you said something maybe via hashtags or whatever,
right.
you could be liable under the online.
Correct. So it seems to magnify the bad effects of the cybercrime.
Sorry, Chris, your thoughts on that? Because this is a special law, so the malice is not. Whereas if you're filing a case under the revised penal code, then you require malice, right? And for this one, you don't require malice. So I could be saying something, again, carelessly, and it could be considered libelous, and therefore I'll go to jail for 8 years.
Well, I doubt the Supreme Court will decide it that way. It will result in absurd consequences, and I don't think they would.
All right. Okay. Now, Tonio Cruz, debating against Senator Angara, as you saw in the video before, said there's no cyberbullying clause in the cybercrime law. Now, what's your take on this as a bullying advocate or an anti-bullying advocate? I should say. Do we need that clause? You think?
Well, we don't, because it's just what do you call this? Libel is a tool. These defamatory remarks are one of the best tools of bullying or causing psychological harm on other people. So it's just a means to commit the offense. So we don't need that.
You don't need that. Do you think, JJ, we need a provision in the law regarding cyberbullying? Yeah.
I think there are certain sectors of society that are particularly vulnerable to online criticism. I think what we've seen in the US is that particularly minors. So there have been children as young as 12 years old or 10 years old who commit suicide as a result of online bullying.
That, yeah.
And I think that in that sense, bullying in general, but particularly online bullying is particularly harmful for these kinds of children, and therefore some protections I think are appropriate in that regard.
I'm with him on that, because well, we do have the anti-bullying law,
but
which covers elementary and high school, but there are those kids also that are, they're not in school, so on and so forth. So we must afford protection also to these kids.
Yes, to vulnerable sectors. Yes. I think there's no argument there, but again, this is one of those things where this is new media. We don't know where this is headed.
Yeah.
We don't know
This is a new frontier.
This is a new frontier, and certainly we're going to make mistakes. And in a situation where something is new, my tendency, or the way I like to think of things, is that let's not regulate it. Let's wait and see where
how this goes.
how it goes. And I think that people eventually will learn how to use the media properly, and sort of separate the noise from the true community, the true signal. So I think that we're in the process of doing that. Right now, it's people gang up on other people, but later on, people will realize there's no point.
All right. Yeah. All right, JJ, I'm sorry. We need to take a short break. More on the issue of online libel when we return. Please stay with us.
Hindi po direkta po tayo yung tinatamaan. But to those po na may intent pong kalabanin po yung gobyerno.
Lalong hindi po tama yun kasi po yung ginagawa po na yun, yung act na yun is against po yun sa cybercrime law eh. So maling paratangan mo yung isang tao ng ganun lalo na sa sa social media.
If you're going to say something na degrading, sabihin mo ng personal. Hindi yung gagamit ka ng something na virtual na kung saan malalaman ng mas maraming tao or mas maraming audience yung makakaalam.
Well, freedom of speech, hindi ba? So, hindi dapat na ganon. Kasi kung ano opinion mo, it's not just an opinion. It's not black and white. So, kumbaga sa everybody can say anything.
Yes, pabor ako doon. Paninirang puri yun eh. Diba? Kaya nga meron tayong mga laws na dapat na batayan. Hindi natin kailangan ilagay sa Facebook or sa mga networking sites. Yung dapat nating sabihin sa kanya.
The cybercrime law, I think, masyado na siyang, parang it's a bit too much.
Welcome back. You're still watching Opposing Views on the Solar News Channel. Our guests for tonight, Attorney Chris Schlao and Attorney JJ Decini. Our question is the online libel clause of the Cybercrime Prevention Act of 2012 beneficial to the country? Now, let's talk about criminalizing it, Attorney Chris. No? In the UN, for example, and according to Attorney Harry Roque, the UN has in fact already expressed in so many treatises and in so many, I think, pronouncements that libel is essentially should be scrapped as a criminal act, and therefore, it more than anything, it's a civil liability. Right. Do you subscribe to that? Because of course they're saying about they're basically pointing out that freedom of expression is an important freedom and should be protected. Your thoughts on that? Because all over the world, at least in most countries, they're decriminalizing libel.
Well, actually, that's not true because legislation versus unprotected speech is still found in several countries, like Canada, New Zealand, France, some states in Australia, and of course the Philippines. I mean, and from a historical point of view, the law on libel has been used to express a collective commitment on the part of societies to protect and vindicate dignity as an essential ingredient of public order. So it has a public dimension. It's not a purely private thing because public order is at stake. When dignity is, there's no assurance that if there is no mutual respect among people, your society crumbles. We are only one word away from civil strife, brawl, so on and so forth. I mean, the offended party will definitely resort to reprisal, and then that leads to a host of other things. So countries have been oscillating on the matter. And I believe that the reason for that is because we are sure that every person has an inherent dignity. And that has to be, that is the difference between a rich man and a poor man. You may not be rich, but at the end of the day, if you're a good man, that's a very good legacy. It's, that you lived a life with dignity. It's something you can leave to your children, and it's at par with people who have accomplished so much. Right. It's something that that's the only thing that a poor man has. Right.
That's a fine point. I'll have to throw this to JJ, but he is right. I mean, for a lot of people, dignity is even more than money or any property. And as Pinoys would normally say, dignidad ko yan, and reputation ko yan, and for some people, that's even worse. If you strip me of my dignity, that's even worse than if you strip me off my car or my other property. And that's the reason why I guess Attorney Chris believes that you should definitely decriminalize anyone who removes that dignity from me.
Sent to jail, somebody who removes that dignity. So I mean, I don't disagree with that if it applies to private individuals. But when you're a government official and a public trust, the public entrusts the powers of the state with you, then your life should be an open book. Your life should be, people should be free to criticize you. People should be free to question whether or not indeed you are entitled to the respect that you demand. And what we don't want to happen is to have somebody who pretends to have a good reputation, will protect his reputation, but in fact is a person who does not deserve that reputation. And as a public figure, as a person with whom we entrust the powers of government and the powers of the state, I think that the public should be informed about the true nature of that individual. And if it causes harm to his dignity, to the type of image that he wants to project, then that's collateral damage. That's a necessary damage because we're getting to the truth. And certainly we don't want to entrust the powers of the state to individuals who will use libel laws to shore up their reputation. So I think that's the kind of attack that I think libel law is being misused.
So let's go to private. You mentioned earlier, insofar as private citizens. Let's say criticism of private citizens against other private citizens. Then you probably have you tend to agree with Chris. Regarding that, no? And therefore, should you agree on the penal I guess nature of libel?
Well, what I'm saying is that I think that if it's a private, meaning a person who is not a public individual,
public figure,
and then he is being attacked in a very public way, I think that is unfair.
And you think that there should
yes,
be
but
penal...
I think that that kind of harm can also be compensated by money, not necessarily by sending somebody to jail.
If something has a public dimension, like for example, if an act jeopardizes public order, I think that the treatment should be different. You know, it should be the same treatment we accord to every malicious, intentional, vicious act, and that is to imprison the person. Because, number one, it serves as a deterrence to other people. We don't want them to engage in similar menacing behavior. Second, we contain the evil, meaning we don't let a rapist be out there in the streets freely mingling with our citizens in good standing because he may rape another unsuspecting girl. So in the same way, we don't allow cyber criminals to be at home with full access to the gadgets because he may continue to perpetrate the act. And why the analogy? Because I believe that verbal abuse is no different from, if not worse than, physical abuse.
Right.
You know,
now,
and then,
I guess you're speaking from experience as well.
Yes.
Chris, maybe can you tell us about your bullying experience and why, if you don't mind, no? And I guess this would bolster your position on why you should criminalize, why you should criminalize.
Earlier, Professor DCD said that we should probably think about scrapping the law because even in the community, in the legal profession, we are not in agreement as to what constitutes libel. I don't agree with that because it's picking on technicalities. Because calling somebody out in the open in front of a lot of people a prostitute, certainly for me, screams wrong. You know, I mean, you don't just rip apart a person's dignity like that. It's wrong. I think we are in agreement that that is an attack on another person's dignity, and that cannot be sustained. People have to be assured that they can maintain dignity. If that is not the case, then our society will crumble. We will see posters labeling other people perverts, criminals, terrorists, or we can even see swastika signs there. You know, celebrating the genocide campaigns of the past. So genocidal campaigns of the past. So it's going to be the face of hatred. That's the society that you're gonna get.
And you having experienced that.
Yes, I don't, sir, kasi I don't have the leverage of a good name. I didn't come from a prominent family. I didn't come from a very wealthy family, but I worked my way up. You know, so all I had was a very good reputation because I did well at school, so on and so forth. And I wake up every day thinking that, you know, I'm not an Olympic champion. I am not the son of a president, but people respect me because of the way I conduct myself. And when people put that in doubt by criticizing the way I look, my body, my competence, and then they ripped apart my dignity by saying that you should die, you're worthless, you are an excrement, you are, you know,
those kind of
they screamed wrong to me, and I don't think that it wasn't just a wrong to me; it was a wrong to society. It has a public dimension. If something like this happens to another person, I mean, I would if this didn't happen to me, but it happened to another person, I would take that as an offense also to me. Because it shakes public order.
You realize it could happen to you.
And my kids.
Yeah, and your kids and everyone else, right? So I'm sure you wanted every one of those who made a comment go to jail, right? So, JJ, let's turn the tables.
Actually,
let's say if it happened to your family and maybe your daughter or a specific member of your family,
yes,
and they had to go through something like
yes,
what Chris went through, don't you want to put those people in jail?
I would feel very bad. I would feel very bad. But you see, the question here is, what should we do, right? So we see that there's this kind of behavior that's happening. Should we stop it by prohibiting that kind of speech? Or should we take the other point of view where maybe we should allow as much speech as possible? So Chris was talking about hate crimes, or sorry, hate speech. So talking about celebrating, say, genocide through Nazism, that kind of speech, for example. Do you prohibit that speech, or should you allow people to counter those arguments so that there's more information and that in the marketplace of ideas, people will reach the right decisions? Now, I sympathize with what happened to you. It was uncalled for, it was unjustified. But I don't think, it didn't make me think less of you. In fact, I thought that you were the victim. I think a lot of people believe that you were victimized by a lot of people. And people were just being mean.
And there are mean people.
There are mean people. But you see, if we stop discussion about that, then the discussion on the other side cannot be heard as well. People who are going to say that, people who are going to defend you will also, everybody will be
probably
stifled.
use the same language against those people who are criticizing you.
So I'm saying, eventually we will realize that this is all useless speech and that it should be ignored.
Yeah.
And in fact, my advice would have been, in a situation like that, to the extent that it's possible, is that you disconnect from the world and you go to an internet-free space for like, I don't know, a week or 2 weeks, let it die down.
Yeah.
And indeed this happened. What happened to Chris happened to a Malayer. I don't know. But there have been subsequent other people.
Now, let's talk about, again, still in connection with the punitive aspects of this law, online libel. There is a provision, the Supreme Court in its dispositive position said that, dispositive portion rather, said that when it comes to libel or online libel, you can't be, it made an exception with online libel and child pornography. In that you cannot be held liable under any other law,
both laws,
revised penal code. Can you expound on that a little bit more?
So the Cybercrime Prevention Act says that when a crime is punishable under the RPC and you commit the same crime through the use of ICT, then you are punished under the Cybercrime Prevention Act and the revised penal code. And on top of that, you can be convicted under both laws. And since the penalty in the the Cybercrime Prevention Act is higher, so it's as if double the penalty plus 1 degree higher.
Yeah.
But in the case of libel, the court said, no, it doesn't apply. So I think what they're saying is you choose. Either you sue under the Cybercrime Prevention Act or you sue under the revised penal code. And I wish I could explain why they reached that conclusion. And I honestly don't know why. I think it's easier to explain or to guess why they did that with respect to child pornography, because I think the child pornography law, there is a specific provision involving use of ICT for child pornography. So I think they saw the double jeopardy aspect very clearly in that respect.
All right. Yeah. Now we need to take a short break. Don't go away. When we come back, the result of our online poll on the issue and the final words of our guests. Please stay with us. You're watching Opposing Views. All right, welcome back. This is Opposing Views. I'm Rod Nepomuceno, and we have with us Attorney Chris Flau and Attorney JJ Dicini. Our debate question for tonight: is the online libel clause of the Cybercrime Prevention Act of 2012 beneficial for the country? Now, JJ, do you think the online libel clause will be prone to abuse, especially for those who are in power? Because now, obviously, you can't. There's now a block in a way.
Yes.
And there's this restriction that that this law will provide, and I think the government is setting us up in a way that so that we can't freely express ourselves against it?
Okay, so unfortunately, this has apparently already happened. In the time when the Cybercrime Prevention Act was being discussed heavily and Senator Soto was being heavily criticized online, he actually threw the threat, right? He said, wait for the Cybercrime Prevention Act to come out. And so, in other words, if you're asking whether or not we can demonstrate whether public officials are willing to use the Cybercrime Prevention Act in order to forestall or prevent or minimize criticism, I think there's already evidence of that because we've seen actually a senator of the Republic make that to make that threat. So I'm saying it goes beyond that. He's a national figure. National issues are of course very important, but I think people are most vulnerable are people the further away you are from the urban areas, you know, where the structure of society is different. Right. People are less educated. People are less knowledgeable about their rights. I think they're more vulnerable to that kind of abuse.
All right, Attorney Chris, your thoughts on that? You think that the government might lead to something where the government becomes, I won't say martial law, unless you just clamp down on me. But I'm just saying, obviously now that this is a victory by the government, right? They wanted this law. And it obviously provides a block for people to express themselves.
I can understand where Professor Zin is coming from. I can understand the fear. It just shows what kind of leaders we have, you know. I mean, these are supposedly the people from whom we expect protection, but turn out to be the ones who would
might tend to abuse it, right?
Yes. But I just believe that, you know, the case you cited probably is one of the rotten apples in the basket, you know, one of the nut cases I mentioned. So it's quite unfortunate.
Be careful.
It's not just one. Probably there.
Is nut cases libelous? When you say a nut case, he's a nut case.
Could be. I said could be.
You didn't mention him.
But you know, I just think, Professor, that we do have sufficient safeguards that it's more difficult for a public official to sustain a conviction for libel because, again, before we even go to that, you know, there are communications that are outside the reach of libel. For example, the privileged communications, everything that our public officials say in the discharge of their duties are protected because we want them to you know, to be honest, to come up with good policies, and then fair and true report are also privileged communications, and then your private communication to another individual in the performance of social, moral, legal duty is also protected. So, and then when you do get to the issue of libel, public officials are held to a much higher standard. There is no malice in law, meaning the law doesn't presume malice on behalf of the public official suing. It's up to the burden is actually on the public official to prove malice. On top of that, following the case of New York versus Sullivan, you as the accused can also interpose the defense of truth.
Only in that case, though.
Yeah, so they are held to a much higher standard. You know, and I can understand why that is the case because we want a robust discussion of public issues. But then again, I can feel you, sir, because we don't have the best officials.
All right. Now we've reached the tail end of the show. Final words, Attorney JJ. What are your last words, or final words, parting words for our televiewers?
I think that. You know, the fight doesn't end here. There are still things that could be done. A bill has been filed in Congress to decriminalize libel. We can fight on that arena. We can also go back to the Supreme Court and ask for rules to be issued. In fact, I'm really considering filing recommendation of the Supreme Court for them to issue rules requiring judges, for example, to take an early determination whether or not a libel suit is indeed being pursued, not merely to attack a person's dignity, but indeed to stifle public discussion of public issues, and therefore get the case dismissed earlier, and therefore get the New York Times versus Sullivan protections in place. So I think moving forward, we should move in that direction.
All right. Thank you very much, Attorney JJ. Attorney Chris Lau, your final words to our televiewers?
Yes. Libel doesn't. The presence of this law does not curtail freedom of expression. Just inform yourselves of the law. That way, you are sure that you can enjoy your freedoms, but do so in a way that...
In a responsible way.
Yeah, in a responsible way.
All right. Thank you very much.
Thank you
to our guests, Attorney Chris Lau and Attorney JJ Decini. Now let's see the results of our online poll. Our question is the online libel clause of the Cybercrime Prevention Act of 2012 beneficial to the country? yes 30% and no 70%. And that's our opposing views for tonight. Tune in again next week for another bold and engaging discussion on today's most relevant issues. I'm Rod Nepomuceno. Good night and God bless.